Hi everyone, it's Grant Abbott speaking. I'm here with Michael Jeffriess. Hey Michael.
Hi Grant, how are you this morning?
Yeah, good. This is probably a long time coming, and I know in a couple of weeks we've got our suite of trusts which will be up and running. This is probably the first time we've actually gone in and had a look at our 5 different styles of companies, and I think that's pretty important because most other obviously online and lawyers, etc., only offer 1, maybe 2 at the most. So we've gone beyond that and now providing obviously companies that link in with leading members, family protection trusts. So there's a lot to get through. Before we get there though, I just want to do a couple of things. With our events, if you see down here, see where it says, so this is in your surge, LYD announcements. If you keep on looking there, when they pop up, there'll be replays of your, like for example, this session today. That replay will be up and available on LYD announcements. Future events and any broadcast stuff will actually come there. So just keep your eye out on that. Make sure that you've got a surge. Another one which is really important as well, if you know how you've downloaded Surge, if you want to get in contact with us at Abbott-Family, because we've got exactly the same system where you can, for example, make requests to us or seek live support. We've now built our team up to 5 lawyers. So we've got Tony, myself, we've got a new tax lawyer, James Mellier, and also a couple of paralegals. So make sure that you go and download from the Play Store the Abbott and Morley app. So just go Abbott and Morley, you'll get the app and then set up your login. There's no cost, it's exactly the same. We haven't obviously got all the stuff that Surge has got, but we have got the ability to make appointments and make requests. And it's a lot easier for us rather than sending emails and all that. And feel free just to ask us any technical issues as well, particularly if you're a strategist member. That's part and parcel of your subscription. In fact, a couple of things coming up. SMSF Accreditation, we've got the 3rd course, 4th to the 6th of April, so that's going to be a lot of fun. Each time I'm learning more and more. So we did one earlier this year. This will be great. I'm not sure. I think our next one's probably going to be a live one, perhaps up here on the Sunshine Coast, coming out late October. So there's a really good gap in between. If you haven't signed up for that, contact Talitha, Talitha, at lightyeardocs.com.au. She'll do a good deal. A suite of trusts on the 7th of April. Oh, and I didn't put in here, just watch out, you'll see in the broadcast, for those of you, some of you may have seen the Moat Castle before, but you've probably not seen the new one. So we're launching, I think it's on the 14th or the 13th of April, our new Moat Castle. So just watch out for that. It's going to be a pretty big launch. We've got everything in there, thrown everything in, just trying to sneak in a successor director as well, and everything is going to be up and running. So just keep your eye out on that one. Definitely this is our one state, definitely next week. Make sure 29th of March that you're going to be on for successor director, which I'll be talking about a little bit today. Most of us, look, you've heard me before. Estate planning is, it doesn't matter which way you go. As soon as you get caught in a family provisions case, everything just goes to an absolute disaster. And look, the no-win, no-fee lawyers, they've got some great tools, including injunctions, biding time by obviously getting deferments of cases, etc. So we've got to be really careful about that, particularly in terms of companies, trading companies, bucket companies, trustee companies. When we have a look at where companies actually fit in, we may have a trading company, we might have a trustee company for an SMSF, trustee company for our discretionary trust, trustee company for our family protection trust, and of course our bucket company as well. So a good stock standard company just doesn't really fit the bill for all of these ones. And so which leads us on to the next one. I mean, you've been around a long time, Michael, and it seems as though, sorry about that, but you have, but it seems that it seems to be standard. And I even remember myself, when I was young, and I think I had my first company when I was 18 or 19, got a shelf company. I think it's just an assumption from accountants that all companies are the same, but they essentially can be molded to any particular situation and need to have a focus, and that all companies are not the same.
Yeah, it's exactly the same as all trusts and all deeds are not the same as well.
Exactly. So when we have a look at it, you've heard about, there you go, the moat and castle. It really is incumbent upon us to look at what's sitting in there, whether it's, obviously, if you're looking at a moat and castle, you don't want the trading. If you've got an existing trading company, you don't want that essentially in there. And I'll show you what we're going to do with that a little bit later on. So these are all the crown jewels, all the wealth, all our core entities such as family protection trusts, SMSFs, leading member trusts, etc., that are really clean skin. And then we start to build a moat around that. Now, the important feature is, we've talked about it before, is that the key asset protection structures are both an SMSF and also a leading member trust or family protection trust. And when we look at those, they're obviously, we don't want to have individuals as trustees, because it doesn't make sense to build this beautiful moat and castle and then have a big gangplank because you've gone through and done an individual trustee. So we need to have a special purpose built corporate trustees for those. There's no way in the world that a good stock standard company really does the trick. And I'll talk about it a little bit later on, but it's very easy to go and upgrade your constitution to one of our special purpose constitutions. Okay, a company is a company, true or false? Well, we all know that's absolutely false. I want to have a look through some weaknesses with standard companies. I'll look at the differences with the LYD standard company and how to go through the process of upgrading. I won't go through the actual process. You went through session, was it last week, Michael, or the week before?
Yeah, Ashley and I went through the process in each different company into a fair bit of detail. Yeah.
So if we can make sure, Chris, today that when this review goes out, or when we send out the replay, there's a copy of the PDF slides, which I've already done. There's also going to be Michael's session that he did with Ash in terms of the companies. That'd be great. Any other information, and obviously the replay. So watch out for that later on. We want to make sure, I don't think, I might be wrong, but I don't see any other online provider or legal firm providing as much education and training around strategies as us by far. I know Change GPS do a lot, and they do a fantastic job around marketing and all that. But certainly a LightYear and AM and Accountants, we make sure that we get down and dirty into the real strategy stuff, and that's our bacon. So we want to go through LYD standard company. I just want to take you through a couple of things there. Then I'm going to show you a leading member corporate trustee. I've got a marked up copy that will also, Chris, if you can send out, of a leading member corporate trustee sample that I did, and I've marked it up for clauses. I want to take you through those. We're going to look at the family protection corporate trustee for a family protection trust, and I'm going to look at that inside of the cleaning up a trading company, and also the protector, which we've done in the past, but I want to have a chat about that as well, and Michael will give his tuppence worth. The only standard company, really, you can just use the replaceable rules which are available in the Constitution, but typically you're going to get a standard company that might have 60, 70 clauses all around directors' appointments, etc. And it's easy to upgrade under Section 137. In fact, it's not 137. It's actually, I'll come and change that later on. It's Section 136 of the Corporations Act. So it's very, unlike deeds, etc., we don't need to resettle. all we have to do is have a members meeting, and a member in that instance is a shareholder. So if the shareholders get together and have a meeting, then effectively you can throw out the old constitution and put in place a new constitution. And it's a very easy process. I did 2 before we came on here. It took me 3 minutes each. So again, we've got to make sure we choose the right ones. The good thing about our companies is you don't need to choose leading members. You don't need to do that because they're all referable back to the trust. They're simply placeholders there to ensure that the leading member appointor, the family protection appointor, is made a director, has veto power, and also transmission of shares, which we'll look at a little bit later on. So again, I'll jump out shortly and make that section 136 of the Corporations Act. It's very easy to do upgrades. We can tailor constitutions. We've done a couple at Abbott-Family recently. So if we have a look at it generally, most of us would say, okay, we've got the constitution and then we've got a shareholders agreement. Quite often they actually need to be really linked in together. With founder shares, for example, we could easily have, we made a request recently that the founders of the business were to be given 2 votes at any board meeting or at any shareholder meeting. Now, we can put that in the shareholders agreement, but that doesn't accord with the constitution. So for something like that, around meeting votes, etc., should actually be in the constitution rather than in the shareholders agreement itself. So shareholders agreement is more like tag and drag. What do you do when you transfer your shares, etc. So that's more that process, that accounting stuff. Whereas when you're looking at the voting, who's going to be director, who's going to be chairperson, all that really good chunky stuff, what is a founder share, they should all be sitting inside the constitution. And you can also make the clauses in there irrevocable, which means that even if we do go and upgrade the constitution, those ones stick and stay. So I found the founder shares are quite useful as a tool. You can in fact set different dividend rates if you want for the founders, make sure they don't get diluted below 51%. So all of that can easily be achieved in there, so that when you have someone like Michael doing IPOs or doing capital raisings, that he obviously needs to look at that. I mean, you would have used founder shares a lot in your
yeah, we do, and it's interesting what you're saying before. We can tailor, and we do. Alicia only reached out to me last week, which I pushed across to Abbott-Family. But one of the great things about LightYear Docs is how movable we are in relation to doing updates, and we can. And we circle those through, but also the fact that we get a lot of feedback from our members in relation to different share classes. And there was one that Alicia was talking to me, which I mentioned to push through to Abbott-Family, that I said we probably should add that into the our constitution. And so when we do get regular requests for additional share classes, we are looking all the time, and we do go through that continual improvement process where we meet at least quarterly. We've scheduled into our calendars where we meet and go through the various documents, and then that feedback's provided to Abbott-Family, who update everything.
Yeah, so a couple of things on that one. We're doing
When's that SMSF training day, coming up as well, Grant?
So the SMSF training day is from the 9th to the 11th of May. So if you've never done an SMSF course with me, the SMSF course is fantastic. I love it. But SMSF is very ephemeral. It's more about protecting family wealth. So when you come there, a lot of it's about getting in line succession, getting this and that. If you've never done a SMSF course with me, when did you do your original training with me? God, that was 2004 or 2005 or earlier.
Yeah, it's under the strategist group.
Yeah, I know. So that's how long it's been around. But every time I do it, the case studies that I have there, they change continuously. So, from that perspective, we're going to be in if you've never done a 3-day training, absolutely get on. We're going to have so much fun. I do these regularly. I might do another one later on this year, but it's just going to be a strategy blowout. Your mind is actually going to just go boom. You know, you're going to get strategies you've never seen of. The funny thing is, I know people will be paying a fortune to go down to the SMSF Association conference, but when you go down there, it's a fantastic networking event, but you're really not going to get any meaty strategies because we go through the legislation, we're going through rulings. One of the ones there, we're going to show how to, if you've got clients who want to buy motels or bed and breakfasts, etc., how to put those in the fund and live in them at the same time. So there's lots of sneaky little opportunities there, multi-generational pensions. Anyway, we're going to cover a lot of that. So if you want to do that, again, just contact Talitha, Talitha, at lightyeardocs.com.au, and she'll do a good deal. Now, one of the big issues with the standard company, and I'm surprised that it sort of never came out. Like, if you have a look at most company constitutions, you're always going to see the concept of the alternative director. So that if I don't want to be involved, I can have Michael take my role as an alternative director, which is fine, and that's fantastic. Now, with that one, the problem about it is when I die, the alternative director dies because he's taking my place. But if I'm dead, then it's nothing there. Which the issue about it, and if you have a look at ASIC guidance note 73, and I don't want to get too heavily into it because we're going to look at successor director next week. But essentially, what we find there is that we need to ensure that when someone passes on, that the rudder or the captain, that there's a captain of that ship, particularly if we're looking at an SMSF corporate trustee. Now, with that one, can I just give you a couple of heads up, and I'll look at this next week. Where you've got an SMSF corporate trustee, there is a limitation on who can be what we call the replacement director or the successor director. Is going to have to be the executor of the estate. So if you look at the will, whoever's the executor, they're the person who's going to be a successor director. Where it's a trading company, who do you suggest normally, Michael? I mean, you can have, family, but you can also have business managers, etc.
As office holders.
Yeah, no. For the example, the successor director, something.
Yeah. The majority of the time, it's probably family members, but we have had some that are business managers. So it depends. I guess it depends on the circumstances. Certainly anything that relates business turnaround, we tend to put someone outside the family group if we can. But yeah.
Yeah, and I also think that it's not just for sole directors or mum and dads. You always need to prepare for the worst, obviously. But even if it's if you've got a unit trust, so if Michael and I have got a suit, which means his SMSF, my SMSF, we both invest in a property development project, then obviously both he and I are going to be directors on the corporate trustee of that unit trust, which is, we want to represent our interests. Now, the last thing that you absolutely need to have a successor director there, because if something happens to me, I don't want, love Michael to death, but I don't want him to take full control of that unit trust. So we need to have someone in there taking our place. So we need to get our thinking in, what happens with these companies in the event that someone passes or loses their capacity. It's absolutely essential.
It's like I mean, you're a big fan of having a company as the appointer in the trust, and I'm strong on that as well. Grant, in relation to it's quite easy to change office holders or change that company over rather than.
I think what I'm going to do is I might actually go and, because I've been dwelling. So what happens in our process is we hear, see, watch something, and then it just takes a while to permeate through our conscious mind into our subconscious mind, where we can pull up all the knowledge that we know and look at the potential downsides, because we look at it again, prepare for the worst, because if you don't, the worst is going to happen. So we look at that and then come up with solutions for it. So with that one, with a company as a appointer, I think it's a great idea. But then we're going to have to make sure that we have a good set of constitutional rules. So if I build that, I'm going to make it just a company as acting solely as appointor of a corporate trustee as well. And that almost talks about almost like being a power of attorney for a company, which again, they fail generally on death. Now, with a LightYear Docs company, again, we've built in a whole lot of succession of family wealth protection, which I do. We've got the successor director solution, which I want to talk about. You can see there from the bottom bullet point. We started off originally just the binding shareholder resolution until we came up short, because we then found the underlying constitution didn't marry up or didn't allow that ability to have a successor director. So what we've built into all of our suite of 5 companies is the successor director solution. I'm going to show you the exact wording for that. But again, once we did that, we then bumped up again, one of our advisors or one of our accountants said, well, hold on, this client, we've got a successor director there, but they're just really worried about, taking on the legal responsibilities, particularly for what has happened in the past. And so for that, we've done a deed of indemnity. So when your client gets a successor director package from us, you get a new constitution, and it can be a leading member, corporate trustee, it can be a whole lot. We're going to look at this next week. So this is just a lead in. I don't want to spend a huge amount of time. But when you have a look at that, the minimum charge, I believe, should be $550 for that package. If you went to a legal firm, you're looking at easily $2,000, $1,200 for successor director, upgrade of the constitution, and then another, $750 for the deed of indemnity, probably even more than that. So, there's some really good value there. For those of you, you can do, if you're just on our best practice or best business solution, then you can do them singly, as we'll see next week. But if you're on strategist, you can do multiple successor directors at the same time. Now, with that successor director, many of you have seen that you can have the person who's your EPOA acting as your successor director. The only problem about that, if I can mention that, is that with that one, with the EPOA, we offer in that package, we give the binding shareholder resolution only. We don't talk about the upgrade of the successor director and also the deed of indemnity. So if you really want to go the whole hog, the best thing to do is obviously use this successor director solution. Now, when you do an upgrade, you make a choice there to keep the existing class of shares, or you can upgrade to the LightYear Docs suite of shares. So that's just our basic. Again, you can upgrade and have a look at the session that Mike and Ash did. It's very easy. Look, it takes honestly no more than 2 minutes to upgrade from an existing standard company to a LightYear Docs company. Now, I just wanted to point out
just a couple of questions in there on that. In terms of, we probably should just clear with Paul Hopkins. What's the process of bringing a client who's got replaceable rules?
Yeah, so again, all you have to do is, that's fine, Paul. It's very easy. Just go in. I know you're a great fan of leading member. It depends on what you're using the company for. But all you have to do is just go on. If it's just going to our standard company, then just upgrade to the standard company. And it's section 136, remember, not 137 of the Corps Act, allows us to throw out the replaceable rules, which is the deemed constitution under the Corporations Act, and put in something a bit more malleable with a bit more cement in it. So that will cover that one. Any other questions at all? Or
Bradley Smith's always got a very detailed question. Converting and updating old memorandum and articles of association or newer constitution, there's special share classes or groups of them. As to who, why, or what happens in certain situations, can you discuss how to best upgrade the old memo and articles to a newer constitution, and to include these special clauses when updating the LID constitution? So effectively, these are irrevocable clauses in the old memo and articles.
Yeah, so what you'll do there, there's a couple of ways to that, Brad, and that's a good question, as I would expect from my good friend Brad Smith. So there's 2 ways of doing that. Within the upgrade, you can there's a button there to choose that the old classes remain and everything else gets upgraded. Alternatively, you can choose to upgrade to ours, which would then destroy, obviously, if you've got irrevocable, that would destroy that. The alternative is if it's getting something a bit over the line, and I think we'll need to understand where the lines are drawn. If it's quite a complex set of classes, you might just want to jump on the Abbott-Family app, send it through to us so we can have a look and exactly what you want. And then we can come back and say, well, we can either do it on LightYear Docs, or alternatively, we can upgrade the Constitution so that those other clauses are contained. And if I did that, what I would do is I'd pull out a schedule of those clauses that are still contained rather than having another set of documents. I mean, many of you, if you read my blog last week, it looks as though auditors are on the warpath for member apps. What we're doing there is that if you need to get a deed of ratification for a member application, please come across to Abbott-Family. We'll look that out. We've put in here 45.5. This is in our standard company, and similar ones are involved in all of our companies. So I don't know any other company provider in Australia that has this particular clause in it. So it means that if you want to go down and do the successor director, you need to have a clause like this. But we've got any director may request the board of directors put in place a binding resolution that a successor director will take the requesting director's position as the director with full rights, entitlements and privileges that the position ensures. The binding resolution to replace the requesting director is to lay out the circumstances as to when the successor director is to replace the requesting director, and may include the requesting director cannot manage the company because of mental incapacity, becomes bankrupt or dies. In addition, the personal representatives or trustee of the person may appoint a successor director. So that also includes, for example, someone who holds your EPLA may also appoint a successor director. So that's inbuilt into the situation. Next week, we'll go through and I'll show you more of the hands-on how to use the successor director. Now, the problem with a standard company and corporate trustee, of course, if you haven't got a successor director solution, you're basically stuffed. For example, if you have no directors in that company, then there's no decision-making board in the company. So the company virtually is like null and void, which then takes it out as trustee. Section 19 of the SIS Act requires that there must be a trustee in order to, so the way it works is you have the SIS Act, has to be a trustee, has to be a registered organisation. If there's no trustee, it's not registered and regulated, which means then you're not, because the only way to get tax concessions under Section 45 of the SIS Act, which links you in with the Income Tax Assessment Act, where all the goodies are, is that you have to be a regulated complying superannuation fund. So if you're not a regulated fund because you haven't got a trustee, what are you? Well, effectively, you're a fixed trust that doesn't distribute its income. And for those of you who've been following Section 100A, it's much the same. The trustee of the fund is actually going to get taxed at 45% on all its income. So again, we need to cover these sort of situations, and generally it's not considered the case. And it's a bit scary because 93%, can you believe, of all self-managed super funds have either one or two members. Which means, and probably around about 60% of those have got companies. So there's a lot of individuals sitting out there. There's a lot of companies out there that are primed for these sort of successor directors. Over time, we'll get more and more family SMSFs, and I'll be talking a lot about that and why we do things completely differently on that course from the 9th to 11th of May. Now, a couple of things. Do all members get one vote? What happens in family law, litigation, and family provisions claims? So essentially there is, I've been involved in heaps of cases around this sort of thing, but normally what will happen if you've got a no-win, no-fee lawyer, and in fact, I had an interesting one just recently. We're talking about success director, leading member, etc., and what happens on the shares. And the lawyer came back and said, well, it doesn't matter, the shares go into the estate and then the executor can deal with the shares. Well, that just shows you the lack of knowledge of the lawyer, because essentially once the shares are in the estate, they are subject to a family provisions claim, and the executor cannot do anything with those shares until the family provisions claim is settled. And if it's like remember the case I showed you earlier with Justice Jeremy Courtois, remember right that first slide, that took 5 years to get to the Supreme Court. Now, in that instance, generally what will happen is the no-win, no-fee lawyer will have the ability to freeze the utilisation of those shares, which means that if there's no directors, they can keep it as such and ensure that the executor can't appoint a director. They may let them do so, but it gives them the negotiating control. In fact, they'll probably, if I was a no-win, no-fee lawyer coming in, I'd absolutely say, absolutely, you can appoint a director, but it has to be me or someone who's aligned to my client. So that's where things get caught up. And I've seen them caught up for 3 or 4 years. And these are corporate trustees of discretionary trusts, family protection trusts, although you'll see that's not really the case for that. And of course, bucket companies where there's huge amounts of money that may well be stored, or UPEs, and obviously self-managed superannuation funds. So we need to make sure that we've got solutions for that. So the successor director is fantastic, in fact, in appointing someone in there as director, but, and can I just say that, but it's still weak. So successor director is really good. It's much better than the standard company. So at least you're going to get continuity of operations, continuity of decision-making. But at the end of the day, it's weak because it doesn't deal with the shares. So what we've got there is we've got the leading member. So you've heard me talk about the leading member before, but I thought I'd do a bit of a deep dive as to why this is different. And so you can see here, simple constitution upgrade to leading member corporate trustee of a discretionary trust. And we've got this for also for the, we've also got this for obviously SMSF's family protection trust are much the same. So let's just go through. As I said, I've marked it up. We'll go through the clauses. This will be part of your notes. Chris will make sure that you've got that. As you can see here, this is that question, Paul, that you related to. So the first, the mechanism we've got there, as you can see, Section 136 of the Corps Act, you just simply need the company members. And it's really strange when we talk about members, particularly in SMSFs, we're thinking about members of SMSFs, but the Corporations Act notes that members are actually shareholders. So we go through that process there. So we get that signed off, and then the new constitution's upgraded. So this is a leading member constitution. It's a really cut down version, mainly because it really doesn't do business. So the whole purpose about this is it's got one purpose, and that one purpose is to act as the trustee of a leading member discretionary trust. You can't use this for the SMSF, and likewise you can't use the SMSF one for this. So let's go through a few ones. So leading member discretionary trust is a trust that provides asset protection and succession planning, control of flow of wealth to lineal descendants and bloodline descendants for leading member appointor. Leading member appointer is the initial person who is provided with the power to appoint and remove a trustee and nominate beneficiaries to trust that this company acts as trustee for. So again, we don't need to note who the leading member appointor is up here, because it's referable back to the trust that it's acting for. We've got lineage, we've got a whole lot of stuff there. So when it comes around to what this does, there we go, I just lost that, sorry about that. Okay, my little computer doesn't want to, there we go. So 3.2, so the company will be incorporated for the major purpose of being the trustee of a leading member discretionary trust. If any provision of this constitution is in conflict with provision of the Corporations Act or regulation made pursuant to that provision or that regulation applies. 3.2, the company may be a trustee of the trust or any other trust related to the leading member, but must not be the trustee of any trust or engage in any other business or any other activity. The company apart from acting as the trustee of the trust, is to also ensure that as trustee, it operates for the benefit of lineage and bloodline of the leading member appointor or such other persons in accordance with the leading member appointor's wishes. So we're giving it a really laser-like focus as to what it can be doing. When it comes around to directors, who may be and who can appoint a director, any person nominated by the leading member appointor may be appointed as director by the leading member, including the leading member appointor themselves. Can you note to Alicia Chris that I know in, I think, the Family Protection Trust, and we should do this with all our leading member trusts, that the leading member appointor is automatically appointed as the director and also chairperson as well. So then down here, you've got the ability to put the successor director in. We remember talked about that one. Now, what will happen here is, let's go down and we'll have a look there. Some of the powers of the directors. The leading member appointer who's director of the company should act as the chairperson of the company, so that's fine, and has an absolute right of veto over all directors' decisions prior to resolution being finalised. And that also comes here, a leading member appointed who chooses not to be a director, they might have a successor director, for example, has an absolute right of veto over all directors' decision. So they're actually the blind controller over that. Now, I'm not sure if you, many of you get the drift on that one, but there are some instances where clients want to have blind control over a trust. And this is the way of effectively doing it by veto rather than ordinary power. Now, when we go down, what we need to do is ensure that when we do set up this, effectively that the only people who hold shares are the leading member appointer at the moment. So if you've got, so obviously you're going to set up the leading member trust. If you've got an existing trust, you can upgrade that, for example, as a discretionary trust. Then in that instance, you have to look at the leading member appointor. Now, if you've got mum and dad in there as equal shareholders, and for example, John Smith is going to be the only leading member appointor, and his wife Sally Smith is the second leading member appointor, then Sally's shares need to be cancelled or transferred to John, whichever is the easiest for you. Because what we do there is we then go down the next pact. If they're joint, then they can both obviously hold it because the shares will go to the other person. If the leading member appointed dies, unless a joint member, leading member appointed shareholder remains, the company is to immediately cancel the former leading member appointed shares. At the same time, the company is to issue 100 shares for all of the company's newly issued share capital to the successor leading member of the trust. And should there be no immediate successor leading member, that member, the trustee of the trust, or under such powers the trust trustee so chooses as the new leading member appointed the trust. So you can see why this is a lot stronger. So if I have a look at, I've got a leading member appointor, so I've got John, and then Sally is the next. Now, in that instance, we might have a corporate trustee. I've got a successor director. So John might have appointed his son Max as a successor director because they're running a business, and that's fine. But we still might, in the event of death, we still find John's shares, even if he's sharing them with, unless they're jointly owned, they're going to be stuck out in the estate. So there's always that problem. Whereas, and look, you have a look at all your trusts that aren't using our leading member, they're all caught by these issues. Whereas if we do it here, on death, Sally is automatically appointed as director, chairperson, and has complete veto power over the trustee. At the same time, John's shares are cancelled, and then Sally's issued with 100 new shares. So the next leading member appointor effectively controls. So it's a seamless process of controlling. That's also useful when we're looking at family law as well. So I'll go down. We can also look at transmission of shares on bankruptcy, mental incapacity, and even on divorce or retirement or for some other reason you want to do that. So that's why our leading member appointors are completely different to anything else. The Family Protection Trust is much the same, except instead of having a leading member appointor, we have a family protection appointor. But again, this is the corporate trustee. If I then took you down to the trust, you would see there it's all about positions, the beneficiaries or principal beneficiaries, the leading member appointor. So what we've got here is a control mechanism up the top, and that's why it's completely different to anything else. Now, when we build a great family structure, if we have a look at this, a lot of clients have got individual assets, and I've called them estate assets. Might be family home, might be investment property, shares, cryptos, all of that stuff. They've also got a trading company as well. All of those assets, so that trading company can lead to a dissipation of all those assets, because essentially what transpires there is that any litigation puts everything on this side of the red line at risk. What we can do is, and I just want to go through a couple of strategies. With a trading company, ideally, this is my favourite go-to here. When we set up properly, we've got the leading member SMSF, and then the leading member SMSF Trustee company. I'm just building in a process now that the leading member, again, if they've got the EPOAs of the other members of the fund, they can be the sole director. And the others don't, they can be members, but they don't need to be directors. Leading member discretionary trust, same, is that if you've got one that's just purely investments, or even if it's running a business, I would suggest you want to switch it to a leading member discretionary trustee. But if it's running a business, it's probably not a bad idea to rip the business out, which we're going to have a look at. With the bucket company, obviously you guys know about that, and with the bucket company, just be careful who the shares are owned by. If you have a look at that Guardian decision in section 100A, and make sure, for those of you who are SMSF members, we've got our first full half-day session. I think it's on around about the 14th or 17th of April. Ash is going to let you know when that is. And for those of you who, did you get your certificate then, Michael? Or?
I did. It looks fantastic. So
yeah. So I've got one here.
You got a copy there?
I've got to put in I'm going to put in my nice gold frame, if you can see it there. It doesn't come up well, but you can see there, accredited SMSF advisor. And part of that, you get obviously a whole lot of education as part of your package. So again, make sure if you've done the course, you've got accredited, you haven't got that, contact Ash. So just ash@smepa.org.au. So we want our leading member fund, leading member discretionary trust, and remember all our goodies we want to have in this family protection trust. And again, that's going to have it'll be a family protection trustee company. So there are our three really good, strong go-tos that sit outside the estate. Potentially the only ones might be the clawback provisions in New South Wales under the notional estate. But apart from that, these are really good, strong, solid go-to structures that the family provisions lawyers, the litigators can't really get in as well. Family law, a little bit different, but we'll look at that for another time. So this trading company is sort of sitting out there and obviously receives a lot of income. It's got a whole lot of stuff. For those of you, we'll send out a link, or you haven't seen it. I did the business protector last week, or I think it was about 3 weeks ago. And again, essentially with our trading company, we can rip the assets out of there, give the assets over to a probably I would put them in. I would put them in as a company into another company, which the shares are owned by the family protection or your leading member discretionary trust. So you got your business there. It's really more like what do you call those sort of companies? Are they more like asset holding companies, or?
Yeah, it's just an asset. We call them asset holding vehicles or companies.
Yeah, so they're pretty popular. There was actually, I was having a look through. Tony sent me a whole set of documents around this exact strategy that was out and about, around about in 2004. and essentially people were charging like 25 to 40 grand for this transfer. So again, this is part of your package up on.
There's still a lot out there who are, Grant. I've seen them.
Yeah.
And they're not even close to as got the amount of documents or coverage that we have within ours.
I know. The big one there is if we give the assets, it's for nil consideration, because a lot of people are saying we're loaning the assets, but if you do that, you've still got the 4-year clawback, but remember it's going to be an insolvency company anyway. We take the assets there, and it really works for enterprises, the small, anyone who's going as a small business can transfer those over to, I put it into another trading company, or as Michael said, that asset holding company. And that would be your goodwill, your whole lot. So I've got a fantastic new charge document, which I'm going to put in there, which would be useful also for you guys at Venom Optimum, Michael, because it goes through and charges all the goodwill, every asset in that company. So effectively, when we have a look at it, we can take those assets over. We can still protect them in the asset holding company, and then when we leave the trading company is going to have to pay market value fees for that. So essentially, at the end of the day, the trading company should just be like a shell. So I know at Venom Optimum, you guys do a lot of restructuring and a lot of debt, etc. I mean, that's obviously one of your big go-to strategies.
Yeah, we do a significant amount. I mean, the business turnaround restructuring space. So, and it's been a big, which I expected. I've spoken to on all these webinars, big uptick since January. The ATO has certainly increased their activity, which is good for business as well.
Yeah, good on ATO.
Good for our business, not necessarily for the client's business.
I know. So, and most of you know about the protector anyway, the gifting of equity. Just remember, with the trading company, we're actually transferring, notice the difference, we're just transferring the assets, whereas when we're having a look here, we're actually gifting the equity. The assets stay in the names of the company, which is good. So I just got a couple of questions and we can stop. So, John, how do you check different share classes from the old constitution, the new LYD constitution? Can you read the new LYD constitution share classes? Yeah, absolutely. So what we'll do is we might put a standard, Chris, if you could just put a template of a standard constitution that we've got for you, John. That way you've got an idea of what our classes are, so you can make that choice.
I think this question's asking if they've got a previous LYD constitution or a previous constitution.
Yeah, so if you've got any of our constitutions, essentially, I think I put them all in play around about June or July. So if you, the best thing to do is if you have a look at section 45 or clause 45 or rule 45.5, if you've got a standard company, for the leading member, I think just have a look at the directors. I think that was something like about 4.3, and that will give you the idea. Otherwise, then just go and upgrade it. With the SMSF, is the executor or personal representative the only person? Yeah, so the problem about that one, that's a really good question, Eddie, for SMSFs is, and we'll look at this when we do the SMSF course, but essentially, as we all know, all members must be directors. There is one exception to a couple of exceptions, but on death, it's your legal personal representative who's your executor or the administrator of the estate. So we can't just we can chuck anyone in as a successor director, believe it or not, but they can only be in there for a maximum of 6 months. So that's why I say don't do it, just in case that 6 months lapse and then you lose your SMSF status. But it's best to actually just put the executor in as that director, which is fine. Brad, if the leading member needs to resign as director due to being sued, divorced, bankrupt, is it possible to have them reappointed later? Absolutely. Yeah. So that's the whole purpose, Brad, is that you can have them appointed. They can come back in once they've got the bankruptcy over. At any point in time, you can change the leading member appointors. So that's a good question. Another one from Mr. Brad. Is there a specific reason you have chosen 100 shares? No, not at all. Look, it really doesn't make any difference. If you think it's a good idea, Brad, more than happy to have a field in the document as to 10, or you can make your own choice. But I've just chosen 100 shares. That's just me. What's the difference between the Family Protection Trust and the leading member? Shane, that's a really good question. Believe it or not, they're all both exactly the same. It's just the different nomenclature. What I do in my head is I use that leading member concept for discretionary trust, business, investment, etc. Whereas the Family Protection Trust, I use that as really like that's the backstop. That's the backstop of the moat. So that we've got the family protection appointer. You can use either or, but that's how I look at it. And I also find, again, when I'm dealing with clients, they love that concept of the Family Protection Trust. And also a good thing is it's not trademarked as yet, or it can't be trademarked. I've had conflicting, I've had conflicting views from lawyers about the effectiveness of gift and loan back. Look, that's really important. Look, Campbell, love you to send through their reasoning on it. But if the best thing to do is if you just jump on Google, do gift and loan back, you're probably going to find 30 to 40 legal firms that do it. It has been held up in Queensland Supreme Court. There was a case going through New South Wales where it was held up, or it was held to be efficient. What happened though is the legal firm got to put money in when actually nominated a certain amount of money in the promissory note, so there was no gift. So that fell to the wayside. Another one in Victoria, essentially, because it was in which a lot of the family protection ones there is to defeat a family provisions claim. What they did is the executor and the trustee of the Family Protection Trust were one and the same, and the court replaced the executor of the estate, which is fine. So that if it's going to be contentious, what I would do is make sure someone else is an executor or joint executor along with the person who is the trustee of the Family Protection Trust. But to date, never been knocked back. So again, I love to, what I always do is when, if someone says that, and this happens all the time, the best thing to do is just simply say, well, that's fantastic. Can you just give me a case authority on why it's not working? And then just sit back and, I mean, remember, you're the one, they're the ones who are bluffing, pretending they've got all the knowledge, and see what they bring to the table. If they don't bring the receipts to the table, then you know it's it doesn't work. When I mean it doesn't work, they don't understand what's going on. What's the benefit of asset holding company versus holding the Family Protection Trust? Look, originally, Eddie, that was a good question. I would have gone down the track and put in the Family Protection Trust, but the problem is if you've got assets in there, there's problems that something could go wrong with the asset, which then brings litigation into the Family Protection Trust. Remember, that's your ultimate vault, that's your crown jewels. It's the last turret of the castle that everything is going to be there if everything else goes down. So that's why you'd have that there. Again from John. Yeah, so yes, an existing old concept with different shares. Do you want to, we'll send through, but maybe John, get that Abbott and Morley app, download it, send it in to us as a request, and we can have a look at it from there. That'd be great. Shane, again, can leading members suite be used if succession is non-lineal? That's no children will want to go to siblings and their children. Absolutely. So again, it's very easy the way that the leading members suite works. So we're moving away from the trustee down to the leading member appointer. We can have, for example, John Smith. If there's no one underneath that, we can have then next one in being Bill Smith and his family. And then what it does is beneficiaries are the leading member appointer future leading member appointors, and obviously their bloodline as well. So that's how you would cover it there, Shane, quite easily.
We've also used it out to outside the bloodline as well, haven't we, Grant?
Yeah, absolutely. So you can. The good thing about it is the way we've drafted up, and I love the way it's been drafted, is that prima facie it goes down to bloodline or lineal descendants, their entities, even their superannuation funds, subject to a couple of tax issues around that. It can go to charities, but also in there you can actually include beneficiaries at any point in time. So you can have what we call like a stand-in beneficiary at any point in time. So they can be declared. So for example, I could say in my trust, it's very easy to do, have a trustee meeting, and that will be signed off by the leading member appointor that Michael is to be a beneficiary of the trust for a period of 2 years or 3 years. So you can put them in. You can also delete beneficiaries or keep specific ones out as well. And we might just finish there, right on time. Manita, can I watch this webinar again? It's really important to watch these on a number of occasions. The more you do, the more you're going to learn. This will be coming out later on today. If you're on LightYear Search, watch out for the announcement. Otherwise, we'll be sending an email to all registrants for that, and you'll be getting a CPD point for this, for FASEA, a Tax Practitioners Board, and of course, SPEPA as well. So do your LYD wills deal with appointing someone as a director for the deceased? No, because they can never do that. The reason that is, if you see a will that actually is trying to appoint someone as a director for the deceased, you know whoever drafted that will has got absolutely no idea. And the reason I say that is that we in fact do the reverse. One is that a will, which is based under state law, whether it's the Succession Act in Queensland or New South Wales, is state-based law. How can you have a state-based law that would force someone to be a director under the Corporations Act, which is federal law? It just doesn't work. And if you have a look at the Commissioner's guidelines on that, or some of the Commissioner ASIC guidelines on that, they say that, in fact, they say you can do a will, but you need to have that binding resolution. You also need to have the company constitution allowing it. So it really needs to be at that top level. You can't do it from a side level being a will, because otherwise it just gets thrown out. It's the same way that you see a lot of people say, well, I've got an EPOA so I can act as the director of the company. It doesn't work at law. State-based laws cannot direct what happens inside a self-managed super fund or a corporation, because they are federal laws. Importantly too, the good thing about the successor directors we'll see next week, you can actually start to use FuSign and digital signatures on that. So that is now guaranteed or enshrined into law. Anyway, closing words there, Mr. Jeffriess.
No, I'm just sorry, I've been manning the chat, Grant. There's some great questions coming through, and certainly it's good to see everyone thinking, considering about this whole thing. I know Campbell put a question up there in relation to the validity of the strategy, and certainly there's definitely tier one, which I mentioned on the chat. Then there's definitely tier one legal firms using the strategy, but it comes down to, which we push forward, and I know you do all the time, the documentation and the quality of the documentation and ensuring it's put into place correctly. I've certainly seen some similar strategies being used, which I've spoken to Grant from some more marketing type companies who the documentation is weak, it's missing certain elements, and I have seen it certainly under attack, but purely due to the quality of the documentation, not the strategy.
Yeah, exactly. And look, at the end of the day, I would rather have it in place and then have the. So if you look at it, that's your first line of protection.
Correct.
Yeah. Not as good would be then having a will as the second line of defence. But if you don't have the first one, then you can't complain. I mean, it's just silly. So, but again, from all the cases so far, there hasn't been one that's knocked it on the head.
I often talk, Grant, in terms of moat and castle, and saying that you build this big moat and we chuck as many crocodiles and sharks in there as possible, and that's your first line of defence. And it doesn't mean that someone can't try and attempt to swim across that moat, whether they make it or not, but you're putting a significant line of defence in first. And if they do get up, then potentially we'll have a fence or a big big gate that they can't get through. So
yeah, and I know, for example, I know Rod, you guys do a lot of restructuring and negotiations. That he did one for a client that only had it going in place for a year, and then negotiated with the insolvency lawyer for 20 cents on the dollar, and that was simply because, because you have to think of from their point of view. One is that it's family provisions. No win, no fee lawyer's not going to do this because it has been tested in court, and it would simply mean they're going to be spending a lot of time and resources for potentially no result. When it's a lot easier to just go and challenge any estate where you can, pick, but it doesn't matter, you can pick up anything really. And again, from the insolvency practitioner's point of view, again, they're going to have to go and challenge it, go to have a look, void the transaction. But so by the time they go and do all that, unless it's a really big case, it's going to be a pretty tough one for that. So anyway, let's stop there. Next week, Successor Director, Suite of Trusts on 7th of April. Hopefully we'll see some of you 4th or 6th. For those who really want to get their SMSF knowledge up at an 8 or 9 out of 10, be a little mini guru, make sure you come along on the 9th to 11th of May. And watch out for this Moat and Castle. It's legendary. There's nothing like this in the world. Anyway, it's Grant Abbott, Michael, signing off.
Right.
See ya.